Hello, everyone, and welcome to PREEMPT Corp. We specialize in conducting federal EEO investigations, counselings, everything EEO related. That's the Equal Employment Opportunity Laws related. I am Wanda M. Johnson, President and CEO of PREEMPT, and we're also known as PREEMPT Inc. as well. I said PREEMPT Corp, but we're PREEMPT Inc. as well, and we were originally created or started in the DC area, the DMV area, where I serve as president and CEO of PREEMPT. And joining me today is my colleague, Dorian Morley, who is our senior EEO advisor here at PREEMPT. Hello, Dorian.
Hi, Wanda. Great to be here.
All right. So we have extensive experience in the EEO, federal EEO industry, and we provide services to the United States government, private sector businesses, independent contractors, everyone that is interested in EEO. And just to be clear, we are different from DEI or diversity, equity, and inclusion and accessibility. We are different because we were created by civil rights laws, and I dare say go back further than that, the civil rights movement that helped create these laws. So we are different from DEI. We have statutory authority that we work under as well. And as I always say, if you want to go back further than that, you can go to the Constitution that says all men are created equal. And if you want to go back further than that, you can go back to the Bible because it's all over the Bible. That's right. Love your neighbor as you would love yourself. There's no discrimination between Greeks and Jews and Gentiles and everybody. Yeah, right. So we have a lot of authority that we derive our superpowers from. I'd like to say that. So, okay, without further ado, what we're going to do today, we're laying out the full federal EEO process. Now, a lot of people are affected by the federal EEO civil rights laws. You have people that are on the private sector, that are affected by EEO civil rights laws, as well as people that work for the United States government. And then you also have the states that have their own labor and employment laws or their fair employment practices laws, civil rights laws, and so forth. So everybody's got some kind of protection under the various laws. And the EEOC, which is the federal EEO, Equal Employment Opportunity
Agency. Yeah, the commission, but agency.
Commission.
Yes.
Thank you. The commission, right? They enforce the federal EEO laws, okay, against federal private sector companies as well as the United States government. So this process that we're going through today is the one that the United States government uses for all of its agencies and so forth. And I dare say that it is the most robust EEO program that is out there. So even if you're a private sector business, and let's say you want to create an EEO program, you could kind of use theirs as a model. You are more than welcome to use that. So we're going to lay out this process today. And before we jump to the process, we're just going to give you a little bit of background about the Title VII of the Civil Rights Act, under which our authority has been derived. Okay. Dorian, did you want to say anything before I go over that?
No, I think you covered it all. We're going to get into it in detail, but we're going to talk about the administrative process, which
thank you,
is required for almost every federal complaint.
Very good.
We'll talk about the exceptions too when we get to it.
Okay, excellent. All right. So what you see now is on our website under the Federal EEO Investigator Certification, where we lay out the genesis of our work. Okay, so the laws and regulations that govern becoming an EEO investigator began with the Civil Rights Act of 1964, which made it illegal to discriminate against someone on the basis of race, color, religion, national origin, or sex. Now,
or reprisal.
Or reprisal. That's right.
That
How
was
could I
included
forget?
too.
That's, oh, okay. That's right. Reprisal. And private sector, sometimes we refer to this as retaliation. They're still cousins. They're still actually brother and sister, I would say.
Yeah.
Let me get out of the sun. It's kind of hitting me there. Okay, so the law makes it illegal to retaliate, and there's our retaliation part, or reprisal. The law makes it illegal to retaliate against a person because the person complained about discrimination, filed a charge of discrimination, or participated in an employment discrimination investigation or lawsuit. All right. Additional civil rights laws include the Age Discrimination Employment Act, the Rehabilitation Act, and the Americans with Disabilities Act, the Equal Pay Act, the Pregnancy Discrimination Act, and most recently, the Genetic Information Non-Discrimination Act. All right. So that's kind of just a general background for that. All right, Dorian, you want to take the next paragraph?
Okay, let me just say too that in 64, these protected categories were identified that you said, race, color, religion, national origin, sex, and reprisal. And then these other acts added age, 40 or over 40, and disability, and equal pay, and that's a gender thing, basically. And genetic information, if you're, because in 1964, genetic information wasn't really a thing.
Nope.
There was not the availability of genetic information like there is today. So it added that, and also added pregnancy discrimination, which is a relatively new act that defined pregnancy when necessary as a disability. And that was a change. Okay, so in 1972, the EEO Opportunity Act amended the Civil Rights Act, and it's commonly known as Title VII of the Civil Rights Act. So we just refer to it shorthandedly as Title VII. And subsequently, EEOC issued Management Directive 110, which we call MD 110,
right,
which is really our Bible for those administratively processing discrimination complaints. That has so much information in it. It provided federal agencies with the EEOC's policies, procedures, guidance relating to the processing of discrimination complaints that is governed by the Commission's regulations that are contained in 29 Code of Federal Regulations, Part 1614. And federal agencies that are covered by 1614 are responsible for developing and implementing their own EEO programs, including alternate dispute resolution programs, which we'll talk about when we get into the process, and complaint processing procedures that are consistent with EEOC's regulations.
Oh, all right, very good. Okay. Now, the other thing I want to say too is that against this historical backdrop, our courses that we have and everything that we do has been designed, of course, with you in mind, because most of the services we offer are on-demand, self-paced courses and training programs, but we do have live instructor coaching and so forth. And before I go to laying out the process, so a lot of the work that we do is affected by this overall process and so forth. So that's one of the reasons why we want to go over this today, just to make it clear for you. And most of these courses are taught by Dorian and myself, and they do comply with Federal EEOC MD 110's bare bones requirements. But we do add our own flavor, our own flair, if you must, to the courses. We don't take away from what EEOC mandates, but we do offer our own experience, information based on our experience of doing this work for many, many years. We've done it for a lot. We perform the services for a lot of the agencies. Both Dorian and I are former federal employees, and our bios are on the website, of course, under the experience section. But my background is I'm a former U.S. Department of Labor Solicitor's Office attorney, and Dorian is a former director of the Complaint Center for the Department of Treasury. All right. But we've been on the government contracting side for a number of years. And so we've provided these services to the agencies as well. All right. So without further ado, what we're going to do, we're going to pull up something for you. Okay, I'm just going to pause.
It looks like a maze at first glance.
Okay, yes,
but we're
right.
going to
Right.
we're going to go over it.
It does. It looks like a maze, but you'll understand it. I'm just going to pause the recording for a sec. Here we go. All right, so on your screen, you should see this flow chart here, which is based on 29 CFR section 1614 of the Code of Federal Regulations, and it goes over the Federal EEO complaint process. Like Dorian said, this is what the agencies generally follow. And another caveat I wanted to remind people about, although this is the federal process, the states are free to provide greater rights than what the feds have. They just can't provide less rights. So they may have a little bit more robust stuff, which I doubt, but yeah, they can do different things because the feds is usually pretty robust. And the other thing I wanted to say, when Dorian mentioned the Age Discrimination Employment Act, here in the District of Columbia, we protect people under 40 years of age. I think we protect people down to 20. I mean, it's been a while since I've looked at it. But anyway, if you're younger than 40, you're protected under DC's human rights laws. And then they have broader protections as well, such as you cannot discriminate against someone based on political affiliation and a whole bunch of other stuff too. So pretty much any basis, just like California is like that as well. So I just want to say that as an aside. Okay, so let's get back to this chart here. All right, so if you're going to be conducting federal EEO investigations, counselings, etc., you need to understand this process. If you are a complainant and you file a complaint, you need to understand. So everybody needs to understand the process if you're going to be filing something in the federal administrative arena, okay? All right, Sister Dorian, I'm going to turn it over to you and let you go through that, navigate that.
Okay.
I've done my job.
Before we get started, I wanted to mention the one exception to using this process that I referenced a few minutes ago, and that is the Age and Discrimination in Employment Act, ADEA, which applies to those 40 and over. Does not require that you enter the administrative process before you go to court. So that is the one exception. It rarely happens that people choose not to participate in the administrative process because it's the best chance to get your case resolved at the earliest level. But that is an exception to the requirements. So everyone else who works for the federal government, is an applicant for the federal government, or used to work for the federal government, who wants to enter the EEO process, who has a claim of discrimination, must follow this process. And it begins with contacting a counselor. So the top line there, alleged discriminatory event occurs, event occurs, and within 45 days of that event, the person must contact an agency EEO counselor. So they have 45 days. We won't go into, but there are a lot of continuing events that may extend that amount of time. But within the last event, counselor has to be contacted within 45 days of that most recent event. Okay, and then counseling is scheduled for 30 days. It can be extended to 90 days, and there is you heard us reference ADR, which is alternate dispute resolution. That can be a part of the process all throughout the administrative process, both informal and formal. And if ADR is elected, and that typically means mediation within the agency, then the time frame for counseling is extended to 90 days. At the end of the counseling period, the counselor issues what's called a notice of right to file a formal complaint. And within 15 days of receipt of that notice, the individual can file a formal complaint of discrimination. When that formal complaint is filed, the first thing the agency does is acknowledge it, and then they review the claim to see if it should be accepted. And they review whether the claim is timely, whether the person entered counseling on time, whether they filed their complaint on time, whether some of the incidents might not be covered by the discrimination complaint laws. For example, Wanda mentioned political status. That is not a federally covered protected category. So that kind of claim would not be acceptable. Also, a protected status that's covered must be included. You can't just say I was discriminated against and not describe by what, covered by what protected category. It has to be one of the categories that has been contained in one of the laws that are covered by this process. So the agency determines whether it's going to accept the complaint or dismiss the complaint. If they dismiss the complaint in full, then the person has an opportunity to appeal that decision to EEOC, to the Office of Federal Operations. They have 30 days in which to appeal that decision. And the EEOC will make a determination of whether the dismissal was proper or not. If they determine it was not proper, they'll send it back to the agency for processing. If they accept the complaint, then they will frame the claim, determine what issues should be investigated. They'll give the opportunity to the complainant to question or challenge the claim that they have framed, but the agency gets to make that determination. And if ultimately the complainant doesn't like the claim that was framed, they can appeal that down the line. The agency may also accept and dismiss parts of the complaint. If part of the complaint is dismissed, then the person cannot appeal that dismissal initially. They can't appeal it until later in the process. They'll be notified of the dismissal and told when they can appeal it, which is down the line after the next process has occurred, which is the agency assigns an investigator, an EEO investigator, and notifies the complainant that an investigation will be held. The investigator, there's a whole process that if you take our training, you'll be familiar with it. The investigator has a lot to do. Develop a plan, conduct fact-finding, write a report. And although it says here the investigation can be 180 days, that's the time limit that the agency has to produce this investigative file. A lot happens in the meantime. It isn't that the investigation itself is going to take 180 days. The investigation typically takes 45 to 60 days. However, a person can amend their complaint all throughout this process, which can which can make the investigation go on longer. So once the investigation is completed, the complainant has the opportunity to request a hearing from EEOC. And if they request a hearing, then the hearing is assigned and either conducts a hearing and the agency will participate in defense during that hearing, or the agent or the administrative judge for the EEOC, rather than conduct a hearing, may issue a decision because he doesn't or she doesn't find that there are any facts in dispute, and they could just issue an order. If the person requests a final agency decision instead of a hearing, then the agency would issue a written opinion. And again, the person would have 60 days to appeal. The agency has 60 days to issue the final agency decision, and the individual has 30 days after that to appeal that decision again to the OFO. If the agency conducts a hearing, if the complaint requests a hearing and the agency participates in the hearing with the EEOC judge, and the judge finds that there was discrimination, then the agency has to issue a decision that comports with that finding by the judge, or at the time they issue the decision, they have to appeal again to the EEOC, challenging, I guess, the decision that the administrative judge made. And that's a change when EEOC revised their regulations some years ago. It used to be that the agency had the option to pay attention to or ignore what the administrative judge says. But now the EEO says you have to do what the EEOC judge says to do, or you have to come to us and say why not.
Right. Interesting.
Okay. So, and that's the part where it says AJ issues decision if discrimination found, orders remedies and attorney fees. And then from there, then the agency issues a final order, which the complainant can appeal to the EEOC Office of Federal Operations. And ultimately, the complainant can file a lawsuit in district court over this matter. They're also in MD 110, which we mentioned was the Bible. Chapter 2 talks about EEO pre-complaint processing, which is the counseling phase. And Chapter 5 goes into detail about the agency processing of formal complaints. So there's a lot more flesh on the bones in those chapters to help to describe what the process is. And the timeframes are very strictly held.
Yeah.
If you are a day late, unless you have some reason to show that you could not file on time, then your case will typically be dismissed by the agency.
Okay. All right. And a couple things I want to add here. Where the AJ, after they issue the decision and say if discrimination is found, order remedies and attorney's fees. Okay, so the attorney fees are reasonable attorney fees, compensatory damages. That means to compensate the person for the discrimination. And then also, Dorian, talk about the HR side, like their pay, back pay, front pay, whatever else. Yes, they may be.
The remedy, if discrimination is found, the remedy is to make that person whole.
Yes.
So if, for example, their claim is that they weren't hired, then, and discrimination was found in the hiring process, then they most likely the agency would be directed to hire them and provide back pay from the time that they should have been hired. Same thing with a promotion, a lost promotion. If there is clear monetary relief available, if the claim involved some money that they didn't get because of the discrimination, then that monetary relief is completely separate from the compensatory damages. That's about making the person whole.
Okay. Yeah.
Compensatory damages, I think, would be such things such as if the person it caused great mental stress and they had to have, they went to the doctor a lot and they had medication, or if they had to spend sick leave because they were so distressed and they can show that that's caused by the discrimination, then that could be restored also.
Right. Now, the other thing too, the law provides for up to, what was it, $200,000?
$300,000 for compensatory damages.
Yes, right. But that's
under Title VII.
Under Title VII, but that's not in the administrative arena, right? Is it in?
Oh, it could. Well, I think it could be. We've had instances where a person makes a claim for compensatory damages, and the administrative judge directs the agency to conduct an investigation to determine, the employee has to provide the evidence, has to provide the documents that show how they were damaged, how they were harmed. Right. And then I believe the administrative judge can make a call that awards these compensatory damages. Right. I don't think it has to go to court for that.
That's what I thought. Now, I know punitive damages are not available in the administrative form. Right. Okay. And you see here where federal district court is the ultimate stopping place there. That would be an option. Punitive and compensatory and whatever else.
Because the complaints are entitled, or if they file a lawsuit, they're entitled to a jury trial. That's another part the changes that were made about, I think, 10 years ago to the process.
Oh, okay. All right. And when they go in, I guess in this arena, they issue a notice of right to file too, out of Office of Federal Operations when they're finished. I would assume I know in private sector, they can move for, they can request a notice of right to file after they file with the EEOC before they start their investigation. They can ask them to close out their case and go straight into court. Go ahead, Dorian.
Right. With the federal case, they can do that after 180 days. If the investigation has not been completed within 180 days, and there are exceptions if they filed amendments and it took longer, but still they can go after that time period and file a claim in district court if they choose to. They don't have to wait.
Okay.
And it's a little shorter if they're claiming something that's covered by the Systems Protection Board or MSPB. And that's the agency that governs the personnel aspects. If somebody was fired, for example, or had a long suspension, they can appeal that to MSPB. And that in that case, the investigation has to be completed in 145 days, and they can go to court after that 145 days. So, you know, the government, there are lots of details and timeframes and particulars.
Yes, definitely. They're very strict on those timelines too.
Right.
They really are. Okay, a couple other things I want to say too. You notice Dorian mentioned very different titles, such as the counselor, the EEO counselor, who is at the beginning stages of the process. Okay, so in addition to providing investigator certification training, we also provide counselor certification training. And also, if you want to learn how to write final agency decisions, we also provide that certification. And we're going to add learning how to write accept dismiss letters too. We mentioned that. That's part of the process as well. So, and Dorian, just quickly, why don't you tell us what a counselor does? The difference between the counselor, the final agency decision writer, and the accept dismiss letter writer.
The counselor has a really important role. The initial process, the counseling period, is considered the pre-complaint period or the informal stage. And it really is the best opportunity to get resolution of a complaint because it's informal. People haven't, may not be glued to their positions, and there may be an opening for resolution. And the counselor has a lot of roles. First of all, they have to educate the complainant about what their rights and responsibilities are. That's one of the things they do. They have to define the claim, their initial determination of what the claim is. So, and sometimes it sounds easier than it is because sometimes in just talking with a person who is now during counseling called the aggrieved person, and talking with the aggrieved person, it may not be clear in their head even what their issue is. And sometimes it is, obviously, but sometimes it requires some work to get to the to the essence of the problem. They provide the option for ADR, alternate dispute resolution, and the agency does not have to participate, but the aggrieved can elect that process, and typically the agency will participate because they want to try to resolve the complaint as well. The counselor conducts what they call an informal inquiry. So there are no affidavits or there's not a lot of written documentation, but they have a conversation with the aggrieved to find out what's going on. And then they have a conversation with the management folks who are involved in the incidents that have been identified by the aggrieved. After they have those conversations, they try to resolve the complaint. They have, they find out from the aggrieved what they're looking for, what would the remedy be for them to withdraw their complaint or reach a settlement, and they convey that to management to see if there's any give and take if there is a way to reach resolution. So that's a part of every counseling process. After that, if there is no resolution, then they issue, as I mentioned earlier, the notice of right to file a formal complaint of discrimination and give them their appeal rights and what happens, explain to them what happens next in the process.
Mhm. Very good. Okay. And how about the accept dismiss letter writer? That's the one.
Okay. So once a formal complaint is filed, then the first thing the agency does is they're supposed to acknowledge the complaint right away. And then I think there's some time frame for them, I think 30 days, to issue a letter of acceptance or dismissal of the complaint. So the tenor changes a bit, and it's a formal complaint now, and there will be, if the claim is accepted, there will be a formal investigation. So the agency person or contractor who's drafting the letter goes over all the material. The person files a formal complaint. There's a written form to file a formal complaint and explain all the details. The accept dismiss writer goes over all that and frames the claim. And I mentioned that the counselor will frame a claim, but the counselor, again, this is an informal part, so it doesn't necessarily mean that's the claim that's going to be framed in the accept dismiss letter. The person has to go through counseling before filing a formal complaint, but meaning that they have to identify the matter during counseling also. They can't go through counseling for one thing and then file a complaint and claim something that's entirely unrelated. But the way the claim is filed, the way the claim is framed, after a complaint is filed, is up to the accept dismiss decision writer. And as I said, the complainant will have an opportunity to review the letter and say, if they don't believe that it's framed correctly, say why. And many times the agency will make amendments, or make some tweaks or some changes to the issue that's framed. And the complainants are given 5 days typically to raise any issue with the acceptance letter.
Yep, very good. All right. And the final agency decision writer, that's this person here. Tell us about that person, what they do. What do they do, Dorian?
This is the time when the agency gives their opinion. All throughout the administrative process, there is no opinion given. The investigator strictly gathers the facts, as the counselor informally gathers the information, then the investigator gathers the facts. The report is issued, and after the report is issued, if the complainant requests a final agency decision without a hearing, then this is when the agency writes down all the opinions, citing regulations, citing legal decisions about similar cases to make a decision as to whether or not discrimination occurred. Yeah. That's the first time that happens, and the last time, really, unless the EOC disagrees, in which case they may have to change their opinion. But that's what the final agency decision is all about. It's the agency's position on the case, and they have to defend their position. They have to explain why they hold this position.
Right. Yeah, it's interesting because, like I mentioned earlier, we have handled many of these investigations and so forth, and it's a lot of paperwork with the government because it's a process. It's a huge process. So they have the paperwork that goes along with everything, like those. What is it? Not the SF. It's the FF. Yeah, SF. Documents.
50s. And remember, this is all about employment discrimination.
Yes.
Every claim has something to do with employment. So human resources records, personnel records are always a part of it, in some form or fashion.
Right. Yes.
And I think the details and the requirements for all of the documentation are really protections for both the complainant and the agency, because it shows like we often say, well, it's great to have testimony, if somebody tell you what happened, but it's
Mhm.
much better to have a document that shows
Sure
that
is.
that was affected. That is what
Yes.
happened.
Right.
So
Yeah.
the investigator does gather a lot of written documentation.
Yes, definitely. Yeah, yeah. Like I said, it's a very robust process. And it is to ensure fairness in the process. That's why it's laid
Yeah.
out the way that it is. So
Right. And we've
definitely.
had investigative files that have
Yeah.
exceeded 1,000 pages
Yeah.
from, now everything is electronic,
Yeah,
which
yeah,
makes
it's
it a lot
digital.
easier.
Yes,
But
that's
I can
right.
remember back in the
Yeah.
day, making 4 copies and compiling,
Right?
gigantic binders of
Yes.
reports. So
Yes, they sure, yeah.
they can be very
I
detailed.
remember
Yeah.
those big cases. Yes, yes, yes. So yeah, it's a lot of information there. Yeah. So
Mhm.
yeah, definite. All right. So we just wanted to take a few minutes and explain the federal EO process to you. And the other thing I want to say about it is that this is a free process. Like you don't have to pay to file a complaint. It's your right. You're protected, and all of the EEO offices, they have these notices posted, and they have EEO offices in every agency. So you have that right to file a complaint of discrimination if you believe you have been discriminated against. And also, although it's not required, you don't have to you don't have to have a lawyer or a representative. You can represent yourself. However, I will say, yes, it does help to have some of these other people assist you with preparing the complaint or whatever, because it has to meet the legal standards and so forth. So, and the
Mhm.
regulatory standards as well. So,
And sometimes when complainants are really upset, they're not
mhm,
as clear-headed as they need to be to explain what happened to them.
right.
And,
Yes.
I've had conversations with lots of complainants, and
Hmm.
it's not an easy time. People
Yeah. It's
are
emotional.
upset. Yeah,
Yes.
very emotional.
Very
Yeah.
emotional. Yes,
Mhm.
because what's important, and it's what the investigator gathers, is the facts. That's
Right.
all that they're looking for, the facts. What are the facts? Because you can say, oh, I believe I was discriminated against because, my supervisor looked at me the wrong way, or my supervisor had a bad day. But we're going to
And
ask
all
you,
my friends agree too. They think I
yeah,
was too.
that's right. That's right. That's right. And we can get a statement from them. They'll say that too. But, if it's not factually based and, it doesn't support the claim of discrimination, the
Right.
requirements, then
What's the
that's,
evidence?
yeah,
Yeah.
right. And that probably falls up under a HR management inquiry, which is the other kind of informal investigation tool that sometimes people use that is that's not covered by Title VII. So,
Mhm.
yes. All right. So thank you very much and for joining us today and allowing us to educate you about the federal EEO complaint process. For more information about our company, Preempt Inc. Corp, whatever you want to call us, you can reach us at www.preemptcorp.com. That's PREEMPTCORP.com. Or you can send us an email, info@preemptcorp.com. Or you can call our office, 202-434-4544. Take care and have a wonderful, wonderful day. All right.
Bye-bye.
Bye bye.